Mr. Goodman can't be here today, so it falls to me to introduce today's topic. My name is Ben Bradley, and I'll be speaking today on this topic with Declan Byrne, who is in front of me. Subpoenas are an important tool for any lawyer. They allow the lawyer to harness the power of the state to coerce citizens to produce documents. This power can be used to great advantage, to obtain documents relevant to your case, or destructive to your opponent's case. Used well, subpoenas can facilitate proof of essential facts. Used poorly or not at all, your client's case can suffer considerably. Having your subpoena set aside by the court and your client ordered to pay costs is obviously a circumstance to be avoided. With that in mind, today's seminar addresses some of the fundamentals of subpoenas. Declan will cover, amongst other things, how to prepare and serve a subpoena, how to produce documents in answer to a subpoena, the mysteries and mechanics of the Supreme Court Subpoena List, and how to deal with non-compliance. And if you're still with us, I will cover some of the responsibilities that lawyers have with respect to setting aside a subpoena and some of your obligations you have in relation to understanding the contents of the schedule. Some important areas to do with subpoenas we won't cover, and we have prepared a paper, which I think all of you should have, and if you don't, please ask for one on your way out. Declan, if you wouldn't mind.
Morning, everyone. Thank you for spending your Valentine's Day morning with us. I know this is exactly where you want to be, exactly learning about subpoenas. So, as Ben said, I'm going to deal with some of the procedural issues in relation to subpoenas. We're going to cover a number of areas, types of subpoenas, whether you need leave to issue them, actually completing the form, serving them, how you produce documents in response to a subpoena, the subpoena list, costs, and non-compliance. So first things first, let's look at the types of subpoenas. So there's three types of subpoenas. You have a subpoena to give evidence, a subpoena to produce documents, and a subpoena which requires both. Most of what we're going to talk about today is in relation to subpoenas to produce documents. Okay, do I need permission before I issue subpoenas? Well, the answer depends on where you are. So you definitely need leave if you're in the federal court. You definitely need leave if you're in the small claims division of the local court. The equity division of the Supreme Court has an asterisk next to it because there's a practice note, which I can't say is new anymore, but it exists. Practice note says that you cannot get disclosure in that list unless all your evidence is on and you satisfy the court on an affidavit that the disclosure is necessary for the real issues in dispute. Now, technically, it does not apply to subpoenas or notices to produce, but there's a number of judgments out there where it's been found that the use of subpoenas can be used to subvert the practice note, and if that is the intention, your subpoena will be set aside. So the only cases where the subpoenas have not been set aside in that list, or that division I should say, is where they're very, very narrowly drafted. So there's one case where Justice McDougall did not set aside the subpoena because it only asked for 4 individual documents, and so that wasn't enough to offend the practice note. It didn't subvert it. Okay, so if you have leave, we actually need to complete the subpoena. Where do you get it from? Normal place, you go and download it from the UCPR Forms website. 3 different forms depending on which subpoena you're after. As you can see, the website also gives you a link to watch a demo. That's a link to a YouTube video of someone filling out an online subpoena. I've watched it. It's riveting. I commend it to all of you if you have some spare time. Okay, let's look at some parts of the subpoena. So the first one, most important, is who is it addressed to in the order to the recipient. So the rules require that a subpoena may only be addressed to one person. So for an individual, that's pretty easy. You just set out name and address. Corporations are a little bit more complicated. The rules require that you address the subpoena to the appropriate or proper officer. So rather than actually identifying the name of the person who is that officer, the convention is that you literally address it to the proper officer, capitalised, of the corporation. And then you put the registered address. Partnerships are a bit tricky again. Notwithstanding the rule that you can only address a subpoena to one person, the High Court has found that you have to address a subpoena to a partnership to every partner. Okay, next part is the proposed access order. So since the Supreme Court overhauled its regime, you're now required to put on the form what proposed access you seek. So the standard position would be, if there's unlikely to be any claims for privilege, that there'd be general access to all parties. If there is likely to be a privilege claim, you'd normally propose that that party have first access for 7 days or whatever appropriate time, given the number of documents, for them to assess whether there is a valid claim for privilege and make an application. Next part, date and times when they must comply. So the date, you can choose whatever date you want, subject to the timeframes, which we'll talk about in a sec. But the important thing is you've got to allow enough time for you to serve the subpoena, and you've got to allow enough time for the recipient to actually comply with it. So if you have particularly broad categories, and a lot of them, I'd suggest making sure that the recipient has a number of weeks to respond. It's pretty difficult if you expect compliance on the first day if you've asked for a lot. The time for a subpoena to produce documents is always going to be in the Supreme Court, 9 a.m. on a weekday during court time. The place is always going to be the Supreme Court, so the 184 Phillip Street address. And the alternative address at the bottom of the screen is just the postal address, which you can get off the court website. So once you've completed the subpoena, you need to file it. So there's two ways to do that. You can do the way that I used to do as a junior solicitor back in the day, whereas you trudge up to the registry with your multiple copies in hand and get them to stamp it. It's $104 for an individual to seal subpoenas and $200 for a corporation. These days, you can always just file it online as well. The added benefit for that is you can print them out as many times as you need, and you've got original copies. I should say the reason you want multiple copies is that the court's going to want a copy, you're going to want a copy for your file, and you're going to want a copy to serve on the recipient. Make sure you retain a copy. It's real difficult if you don't. I've seen it happen. The next issue is how you serve the subpoena. So the rules require that we serve subpoenas personally. So for corporations, that means serving on a principal officer or in any other matter permitted by law. So the most common way to do that is under 109X of the Corporations Act. And of those ways to serve, the most common way is usually just to send by post to the registered office. However, if you do that, it's important to keep in mind how you can prove service at a later date, because the time and date of receipt can often be controversial. So I'd suggest if you are going to post, you should use something where you can track, like Express Post, where you get your tracking number and you go onto the Australia Post website the next day. Or couriers these days, you can ask for a signature from the recipient, which is a good way to prove service, so you can put that in your affidavit. Individuals are a little bit trickier. You need to leave the subpoena with the person, and if they don't accept it, you need to put it down in their presence, telling them what it is. So the easiest way to serve individuals is to engage a process server. They're very experienced at this. They're useful in tracking down people who avoid service, and they have all these standard affidavits of service templates that they can knock out pretty quickly. Okay, time for service. So the timing's important because this recipient need not comply with the subpoena unless it's served within time. So the obvious question is, how long do you have to serve it? So the rules require it must be served within 5 days before the return date, unless you get a different order from the court. Helpfully, that rule 33.3 subsection 8 does not tell us whether that's business or calendar days. However, helpfully, the rules say at 1.11 subsection 3 that if the rules prescribe a time for doing something that's 5 days or less, you don't count the days on which the registry is not open. So the 5 days is business days, so make sure you take that into account when you're serving. Okay. The next issue is conduct money. So the rules require that a recipient of a subpoena need not comply with that subpoena unless conduct money has been handed to them a reasonable time before the date for compliance. Now that only applies in relation to a subpoena to give evidence. There is no equivalent rule in relation to a subpoena to produce documents. conduct money is also required for all subpoenas served interstate. So the question then becomes of what is conduct money? So it's defined in the rules to be a sum of money or its equivalent sufficient to meet the reasonable expenses of a person required by the subpoena to attend court. So the obvious question that flows is, well, how much is that? And I'm going to give the lawyerly answer and say that it depends on the circumstances. It's meant to cover the person's costs of actually turning up to court on the day and going home. So it's going to be different depending on whether the person's based locally or based a long way from the court. I understand that the in vogue thing at the moment is to issue the subpoena with a cheque for about $30, and then you wait for the subpoena recipient to complain that that's not enough, and then you start negotiating from there. Okay, producing documents. If you're a producing party, there's 3 ways to do it. It's quite easy these days. First option is you can post or hand deliver it to the registry. The rules technically require it's meant to be there 2 days before the return date. You can now email it to the registry, which will obviously depend on the size of the documents you're producing. And the third option is to turn up in person at the return of subpoena list on the day and hand over the documents to the registrar. Some common questions in producing documents. First of all, are copies okay? And yes, absolutely. The registrar and the parties would prefer copies. From the registry's perspective, they like copies because at the end of the matter, they can just destroy them. They don't need to return them to the party. However, you have to be careful. In drafting subpoenas, if you want originals, you need to say original. Sometimes it is important to get the original documents. But the default position is that copies are permitted. The second is, can documents be produced electronically? And again, absolutely. The registry much prefers documents are produced electronically on a USB or hard drive or a CD or whatever you've got. They say that they prefer documents to be stored in PDF, but native files are okay too. What about bulky or hazardous documents? So the practice note says that if you are producing more than, I think it's 3 standard boxes or 5 archive boxes, that's what's called a bulky production, and the registry will not accept it. For the record, I don't know how much a standard box is, but I'm going to assume it's about a dozen lever arch folders. In that case, the subpoena recipient holds onto the documents, but just sends a note to the registry and the parties saying there's a lot of documents. We've got them collated, they're kept at this address, we're happy to comply with whatever order the court makes on the return date. The practice note, as I've got up there, also prohibits the registry from receiving hazardous documents. I have no idea what that could possibly mean, but there you go, it's in the rules. Okay, so the subpoena lists. We've got the basics, so it's 9 a.m. each weekday morning. It's usually in Court 1A in Queen Square, which is the only floor down below the main lobby. It's commonly referred to as the Subpoena Dungeon. Let's go somewhat lovingly. It's the old bail court, so it's right next to the jail cells. No natural light and no phone reception, so make sure you get your instructions before you go down there. It's run by a registrar, and it usually takes somewhere between 5 or 10 minutes and an hour, depending on how many matters in the list and what day of the week. For whatever reason, some days are more popular than others. So the next question is, how do I know if documents have been produced? Now the answer is you go to the normal Supreme Court court list and you scroll down. At the end of the list you should see something like this, and you click through and you get the return of subpoena list. And just to have a bit of a closer look at this, this is what you see for each matter. So in the top left-hand corner, you'll see there's the 1. So that's just the list number. And then in the first column under packet ID, you see a whole lot of long numbers to identify the packets. Now, most of those numbers are unimportant. The only thing you need to take note of is the last 2 letters and numbers. So for that first line, S4 is what you need to know. So that first line, those documents refer to packet S4. So it's important to know the packet number, because when you're seeking access or arguing about anything in front of the registrar, they're not going to want to hear anything until you say which packet you're talking about. So S4 would be the packet. So obviously going across, you can see from the producer column that is a packet of documents produced by the Department of Ageing and Disability. And if we go to the other side of the list, you can see there's been a privilege claim in relation to those documents. And in the access condition type, you can see the details of that claim. Okay, so what happens if the subpoena is returnable, but there are no documents in that list? Very simply, it means that the documents have not been produced, or at least they have not been processed by the registry. So I should say as well that there's an updated version of that list that's often left in the bar table. And so it's important to check that just in case there has been some late production. If no documents have been produced, what you're going to need to do is you need to adjourn the subpoena. So this is really easy. If it's by consent, there's no need to appear. All you need to do is enter the details in the adjournment book, which will be left on the bar table. It's a very technical document. It's just a white folder that includes a table like this. Just complete it. Very self-explanatory. Nominate the date for everything to be adjourned, and then as the issuing party, you have to notify all the other parties and the recipient of the new adjourn date. If you don't agree, you need to appear and argue it before the registrar. And another relatively common scenario is that everyone forgets that the subpoena is returnable, including the issuing party and the recipient. If that happens, it's not the end of the world. The practice note allows you just to write to the registry that day and ask for a new return date. Okay, so assuming that documents are produced, you need to get an access order enabled to actually see the documents. So as we talked about, the standard form of a subpoena requires you to nominate a proposed access order. If it does not nominate one, general access is presumed. So if all that the parties want is the access order that is nominated on the subpoena, there is no need to appear in the list. At the end of the list, the registrar will make a default access order in that they will say that the proposed access order nominated on a subpoena is made in respect of all packets of documents that have been produced, unless they have made an order to the contrary. So if everyone agrees or no one disputes the proposed access order, it'll be made automatically. Again, if the parties don't agree on the proposed access order, they'll need to argue the point before the registrar. And importantly, you'll have to, if you want to change the access order, or argue about it at least, you have to give the other parties notice before the return date. And the registry will often want to see proof that you've done so before they grant a different access order. Okay, so some common types of access. So general access and first access we've talked about. Another common form of access is immediate access. This is because often subpoenas, despite best intention, get adjourned a number of times so that they end up being due right on deadlines. For instance, it's not uncommon for a subpoena to be returnable at 9 o'clock before a hearing starts at 10. In that case, you want immediate access so that you can see the documents before the hearing. You have to appear before the registrar, and if you convince them, they'll write you out a handwritten slip, which you can take up to, I think it's level 4 of the Supreme Court building, and you can get immediate access to those documents. Saves the time that the registry usually takes to process all the access orders. Okay, so if you've got your order, how do you actually get your hands physically on the documents? So electronic documents are quite easy these days. Once the registry processes the order, which usually takes a couple of hours, you should be able to download them off JusticeLink. Practice Note also allows you to email the registry asking for them to provide them to you. I think they send you a link. Hard copy documents, it's a little bit more involved. There's a Practice Note, SC Gen 3, which deals with how practitioners get access to court documents. Requires you to fill out more forms from the solicitor on record and letters of authorisation in order to get pre-approved, and you've got to lodge that form. I think it's a day before you intend to go and get access to the documents. So there's quite a lot of rigmarole. The alternative is you just engage a approved copier, like Law and Order or Lit Support. They're already pre-approved. They can go up and uplift the documents from the court, take it back to their office and copy them much more efficiently than you can using the I think the 1 or 2 photocopiers that are in the subpoena floor. Okay, next topic, costs of compliance. So the court has the general power to order an issuing party to pay the amount of any reasonable loss of expense of a subpoena recipient incurred in complying with the subpoena. Now, this is separate from the conduct money that we talked about earlier. In making such an order, the court must be satisfied the parties have attempted to agree on costs, and I would suggest exploring negotiations extensively. These are not the types of fights that the court wants to deal with. If there is no agreement, the proper course is for the subpoena recipient to file a motion and an affidavit. The practice note says that the application should be made on the return date for the subpoena. It also says that the registrar will try to deal with it on that occasion, or if not, adjourn it to another list. In practice, I've never seen costs argued in that list, so you're more than likely to be adjourned. Also, this conduct money, the failure to pay it in advance of production is not an excuse for non-compliance. So recipients of subpoenas to produce documents need to produce the documents first and then argue about payment later. Although I'd strongly suggest opening a dialogue with subpoena recipients, particularly if you've got broad categories, because you don't want them running up the bill and being stuck with a large cost to negotiate after the fact. Okay, now for the fun stuff, non-compliance. I should start off by saying that in 99% of cases, a recipient will not produce by the first return date. You are going to have to adjourn at least once. So what do you do if people don't produce? Well, firstly, you can potentially get a contempt order, because the failure to comply with subpoena without a lawful excuse does constitute contempt under the rules. However, it's a little bit more difficult than that. You need to be able to prove that, as at the return date, the subpoena recipient had documents that fell within your categories, and then they willfully chose not to comply. So you need to show deliberate action or inaction that is not casual, accidental, or unintentional. And even better, you need to do all of that to the criminal standard. So it's quite difficult to establish. The other, more extreme alternative is arrest warrants. So the Civil Procedure Act gives us the power, gives the court the power, I should say, to order the arrest of someone, including the proper officer of a corporation, for failing to comply with a subpoena. Unlike contempt, all you have to prove with this one is non-compliance. Although you can see by the use of may in subsection B that this is discretionary. So I'd suggest not applying for an arrest warrant on the first return date for a subpoena. I've done some searching. I haven't been able to find a single case where an arrest warrant's been issued for a failure to comply with subpoena to produce. Seems to be a fairly regular occurrence in criminal hearings where people don't turn up to give evidence. This happens, but I'd suggest it's used sparingly in civil matters in relation to subpoenas to produce. Okay, well, that's the procedural issues that I'm going to deal with. I'm going to hand over to Ben to talk some more about the schedule.
A subpoena to produce is a written order issued by the court. There can be significant consequences for non-compliance. I've set out note 15 of the standard form subpoena, which notes that it can be contempt and you may be subject to an arrest warrant. For an unsophisticated recipient of a subpoena not involved in court processes and a third party to or non-party to litigation, this can be an intimidating document to receive. As such, care should be taken by legal practitioners involved in the preparation of schedules to the subpoenas to ensure it is prepared in accordance with the rules of the court in which it is issued. This section of the talk considers limitations to be kept in mind when drafting schedules to subpoenas. It will cover the proper identification of the documents that are subject to the subpoena, the proper scope of a subpoena, the obligation to avoid oppression, the abusive process, and privilege and public interest immunity issues. Looking first to the proper identification of subpoena material, UCPR 33.34 is as follows. A subpoena to produce must identify the document or thing to be produced. This is not a hard concept. A schedule must identify the document to be produced with sufficient particularity to enable the person to know what they should produce in answer to the subpoena. It is not a substitute for discovery and is not for the recipient to determine whether any particular class of documents is relevant to issues in the proceedings. In a case that's often cited, Patonga Beach Holdings, Justice Barrett put it this way. The requirement under Rule 33 is that a subpoena to produce documents identify the document to be produced, That is, cut the document out from the universe of documents by some description and specification. It is permissible for a subpoena to call for example, all documents recording oral communications between A and B within a stated period and referring to a particular company. Such a subpoena satisfies the requirement that there be specified with reasonable particularity the documents that are required to be produced, but it is not legitimate to use a subpoena for the purpose of endeavouring to obtain what would in effect be discovery of documents. One such schedule that I recently found which clearly offended this principle was considered by Her Honour Justice Callum in Smith and Jones, which sounds like the name of a case we sat during university exams. Anyway, all documents, this is the schedule, whether stored electronically or not, concerning or relating to the child, this was a child sexual matter, the plaintiff or the mother, including but not limited to all notes, memoranda, witness statements, statutory declarations, medical records, medical reports, publications, articles, stories, and correspondence. This clearly lacks reasonable particularity. Apart from identifying three individuals, there is no subject matter identified, there is no period of time stated, it is in extremely broad terms. And as Her Honour said, when considering this particular schedule, it does not carve out from the universe of documents likely to be held by Bravehearts, the recipient, any particular documents. It would, it seems to be necessary for someone in order to comply with the subpoena to trawl through a very large number of documents to see whether there was any reference or relation to any of the three named persons, and she set it aside. If a schedule fails to identify the documents sought to be produced with reasonable particularity, the subpoena is to be set aside on the basis of what we all know is termed fishing. This brings me to the second thing to take in mind, which is the proper scope of a subpoena. Even if a schedule has been drafted with sufficient particularity, it must be of proper scope relevant to the issues in proceedings. That is, the documents identified in that schedule must serve a legitimate forensic purpose. They must be relevant to issues in the proceedings to which the documents are sought. To be clear, that does not mean that the documents identified in a subpoena must be limited to documents that satisfy the relevance in Section 55 of the Evidence Act. However, the documents must nevertheless have sufficient adjectival relevance to issues in the proceedings. In another often cited case in this area, Trade Practices Commissions and Arnott's, Justice Beaumont said the test of adjectival relevance is satisfied if the material has apparent relevance. In my opinion, in that particular case, His Honour said the documentation called for here could possibly throw light on issues in the main case. In my opinion, adjectival relevance is established. The test has alternatively been stated to be that if it appears on the cards that the documents sought will materially assist in the determination in the issues in dispute, they are sufficiently relevant and have a sufficient legitimate forensic purpose for them to be included within a schedule. The starting point for identifying whether documents could possibly throw light on the issues in the proceedings must be the pleadings, affidavits exchanged, and the legal principles which govern the claims for relief. In addition to facts in issue in the proceedings, a subpoena may also be adjectively relevant if it seeks documents relevant to credit. In short, if you are drafting a subpoena, you should have in mind the legitimate forensic purpose for which the documents are sought. It is good practice to ask when preparing a schedule to a subpoena, how could these documents inform a fact in issue or assist resolve a matter of credit? Indeed, if the subpoena is to be challenged, that is the exact question the court will ask. And as said again in the Al Taston matter, it is the duty of the court where the issue is raised to require the party calling a subpoena to produce documents to identify expressly and precisely the legitimate forensic purpose for which access to documents is sought and to refuse unless such an identification is made. And if anyone's been in the district court motions list and there's an application to set aside a subpoena, the very first question the judge invariably asks is, which paragraph of the pleading does this subpoena go to? And if you don't have an answer to that question, you need to say it goes to this paragraph, or it goes to this affidavit, or it goes to this credit issue. But you must be able to identify, if you want to hold on to your subpoena, the legitimate forensic purpose for which the document has been prepared and the documents are sought. And so it obviously helps to have an answer to that question before someone has to go up there and explain it to the judge. This brings us to the third matter to keep in mind when drafting subpoenas, which is oppression. Even if a schedule to a subpoena is drafted with reasonable particularity and seeks documents with adjectival relevance, it may still be set aside if it is oppressive. A subpoena may be set aside as oppressive if it imposes an unduly onerous burden upon a person to collate and produce documents sought. Seems to be the general test. One of the issues relevant to determining whether a subpoena is oppressive is whether the subpoena calls for voluminous documents, or documents kept in multiple locations, or documents kept in dispersed locations. Even though those documents are relevant, their production may not be justified. In Commissioner of Police and Tuxford, a subpoena was issued for originals and all copies of briefing papers and other materials held by numerous individual police officers, as well as various operational headquarters. The court set aside the subpoena on the grounds, or many grounds, but including oppression. In relation to oppression, it said, no attempt was made either in the district court or in this court to justify the demand for production of all of the copies of these documents. And on this ground alone, given the number of documents involved and the fact that they are or may be located in so many places, means the subpoena was oppressive. So you need to satisfy yourself if you're going to ask for all copies of a document that exists to be produced to the court, for example, which is in itself, I would have thought, onerous unless there was a really good reason for it, whether what you are actually seeking to produce to the court is necessary and relevant, and whether it's proportionate to the matters in issue. And keeping that last statement in mind, the court will also, of course, have regards to the dictates of justice and other matters set out in 56 to 60 of the Civil Procedure Act. So if you are facing an application set aside on the basis of oppression, you will also need to be able to address why it is that it's consistent with the dictates of justice to have the schedule formed in the way you have. And this brings us to the next matter, which is abusive process. It almost goes without saying that a subpoena should not be drafted if it is an abusive process. Indeed, it will be an abusive process if it lacks sufficient particularity, does not seek documents relevant to proceedings, or is oppressive. But there are many ways in which a subpoena can be an abusive process. And generally in this area, a subpoena must not be issued for other reasons than obtaining relevant evidence in the proceedings in which it has been issued. In that regard, it is important to be aware of the general disclosure restriction that applies to litigants to proceedings and to all of us, and that is that information that is obtained by discovery or subpoena cannot be used for a collateral or ulterior purpose unrelated to the proceedings in which the information is obtained. This is known as the Harmon Undertaking, and a breach of that undertaking can result in a finding of contempt of court. In general, the undertaking remains in place, pending an order releasing the undertaking by the court, or documents are received in evidence in open court. A subpoena should not be issued if it seeks to undermine that undertaking. And a good illustration of where that was sought to occur was a matter called Lemery Holdings and Reliance Financial Services. In that matter, a subpoena was issued to a third party known as Bathurst Street Proprietary Limited for material that it had received in answer to a subpoena in separate proceedings. And in that case, Justice Barrett said, I think quite helpfully, the vice in the subpoenas that they are a process of the court that compels a course of action by Bathurst and Mr. Moody, which is contrary to an obligation to which they are already subject by reason of the court's process, and that this conflict has been created without even a request that the court determine that the new compulsion should override the pre-existing obligation, let alone any considered determination that that should be so. This is an important element of the abusive process which I've referred. It is not to the point to say that the abusive process might, in the long run, lead to the same destination as due process under Rule 33.13. It is important that we are mindful that a subpoena does not seek production of documents that would undermine a Harmon's undertaking or any other court or statutory process. And that brings us last to the issue of privilege and public interest immunity. I'm not really discussing privilege, but it's useful to keep in mind that there are three steps that arise on the issuing of a subpoena. There are three processes. The first is the production of the documents by the witness. That is where a person receives a subpoena and they come to court and they hand the documents to the judge. That's what we call production. This step involves the determination of any objections by the witness to the subpoena. It's at that point that most of the issues that I've raised today would be raised. That's where you say it's oppressive or it doesn't have sufficient particularity or those sort of issues. The second step in the subpoena process is the decision of the judge concerning preliminary use of the documents, which we call access. And this includes whether or not permission should be given to a party or parties to inspect the documents. It's then you would ordinarily see a claim for privilege, and Declan put on the slide earlier that one government department had or someone had claimed privilege over a particular document, and that's the time that you would claim privilege. And the third, of course, is the use as though material in evidence, whether it can actually be admitted as admissible evidence in a hearing. It's important to know the stage that you're at in the process when you are seeking relief against a subpoena. There's no point if someone has produced documents to the court to seek to have the subpoena set aside because the documents have already been produced. So you just be mindful of the appropriate relief to bring at the appropriate point of time. You might be wanting to restrict access, but if the documents have been produced, there's no point in setting it aside. This talk has primarily, of course, been concerned with those issues that affect the production of documents. However, practitioners should keep in mind that sometimes the court will agree to set aside a subpoena on the basis that it violates a public interest immunity. Section 126B of the Evidence Act is in the following terms. The court may direct that evidence not be adduced in a proceedings if the court finds that adducing it would disclose a protected confidence. And the reason why I raise this is that there are at the moment a lot of child sexual assault matters and issues of public confidence, and subpoenas are increasing regularly. Whilst the Evidence Act is directed to the admissibility of evidence at hearings, it is well established that it also guides the scope of permissible compulsion of documents at an earlier stage. As such, a subpoena may be liable to be set aside if it seeks production of a document that would otherwise disclose a protected confidence. And the principle, if you come across this issue, is set out in Goldie and Goldie, which has been considered in some other cases. The court needs to consider, and that case involved a father who sought production of documents that were held by Kids Helpline. And Justice Dorr said, the court needs to consider carefully both the usefulness of any information that might be obtained from Kids Helpline and the question of the public interest immunity. There is no specific legislation which would deal with these particular circumstances, but the common law is significant in that the court should be very wary about issuing subpoenas to an organisation which relies upon its confidentiality for its very existence. The benefit of the services provided by Kids Helpline to the children and young people who use that service is significant. And indeed, I have successfully resisted a subpoena on the basis of a public interest immunity where it sought disclosure of documents that would have disclosed that a child had been sexually assaulted, and as a result of that, the court was quite happy in that particular case to resist the production of documents in answer to a subpoena on the basis of public interest immunity. So in all, if you sit down to draft your next subpoena schedule and you are able to identify the documents to be produced with sufficient particularity, you have an answer to the question, what legitimate forensic purpose do these documents seek? You have satisfied yourself that the production of these documents will not be oppressive, and the cost and delay that may be occasioned by issuing the subpoenas does not offend the dictates of justice. You have satisfied yourself that the documents are not an abusive process serving to undermine any court processes or undertakings and does not offend any public interest immunity, then you may issue your subpoena, which of course is the process by which all of you prepare your schedules to subpoenas. And eventually someone might actually produce a document in answer to it. Does anyone have any questions? You're all dismissed. Thank you very much for coming, and enjoy your day.